All right, good afternoon and welcome. My name is Jay Krishnan. I'm on the faculty here at the law school, and I'm delighted to be here to introduce what I think is going to be a really terrific symposium this afternoon. The title of today's session is Public Interest Lawyering in the U.S. and Beyond, Limits and Possibilities. And we have, in person, three wonderful guests, and hopefully on the screen remotely we'll have our other wonderful guests. We're working out the technological issues as we speak. So I should also say that this event is being co-sponsored by the Center on the Global Legal Profession and the Center for the Study of Law, Society, and Culture. And the way this will work today is that each of our speakers will be talking about their research experiences related to public interest lawyering, and they'll spend about 15 minutes or so on their presentations. The moderator will be Professor Ethan Michelson, who's sitting right there, and myself, and we'll take questions as soon as the presentations are over, and we'll interject if we have anything else to say. So is Becky?
Yes, Becky is good to start.
Okay, good. All right. So let me just begin then by introducing our guests. Professor Rebecca. All right.
There's always a thing.
There it is. Right. All right. So Professor Rebecca Sandefur is joining us via teleconference here from the University of Illinois. Becky was supposed to be here, but some of you may have heard there's a blizzard in Illinois, so that's why she wasn't able to come. But we're lucky to have her here virtually, and Becky, we're happy to see you. Professor Sandefur is a professor of sociology and law at Urbana-Champaign. She's also a faculty fellow at the American Bar Foundation, where she founded and leads the foundation's Access to Justice Research Initiative. Professor Sandefur's research focuses on inequality, particularly as it relates to the law. Her scholarship includes investigations of work and inequality in the legal profession and other professional occupations. And she's also done important work on lawyers' pro bono service and ordinary people's experiences with common problems that may often and do often bring them into contact with the civil justice system. Professor Sandefur earned her BA from the University of Wisconsin and her PhD from the University of Chicago. Our second speaker will be Professor Scott Cummings from UCLA. Professor Cummings is the Robert Henningsen Professor of Legal Ethics and Professor of Law at UCLA's School of Law, where he teaches and writes about the legal profession, public interest law, and community economic development. He's the faculty director of a new program, Legal Ethics and the Profession, which promotes research and programming on the challenges facing the contemporary legal profession. He's also a longtime member of the UCLA David Epstein Program in Public Interest Law and Policy, a specialization training students to become public interest lawyers. Professor Cummings received his BA from Berkeley and his JD from Harvard Law School. Our third speaker is Professor Ann Southworth from the University of California-Irvine. Professor Southworth teaches and writes on the legal profession and lawyers who serve causes, with an emphasis on lawyers' norms, professional identities, practices, organizations, and networks. Her research focuses also on civil rights and poverty lawyers, lawyers involved in national policy making, and advocates for conservative and libertarian causes. Her current research includes the discourse, resources, strategies of public interest law organizations and their lawyers. And Professor Southworth's a graduate of Stanford Law School, where she's received her BA from Stanford as well. And our final speaker for the afternoon will be Professor Ben Liebman from Columbia University. So again, the title of our session is Public Interest Lawyering in the U.S. And Beyond. And Professor Liebman brings the beyond dimension to our discussion, as he is one of the foremost scholars in the world on the Chinese court system. Given that China is such an enormous actor in much of our own economy and political discourse today, we felt it was vital, and we're really grateful to have someone of Professor Liebman's stature to be here with us today. He's a professor of law and director of the Center for Chinese Legal Studies at Columbia Law School. His research focuses on Chinese tort law Chinese criminal procedure, and the impact of public opinion and populism on the Chinese legal system. Professor Liebman has his bachelor's degrees from both Yale and Oxford and his law degree from Harvard Law School. Now, I should say that each of our guests here are incredibly prolific scholars, and it would take me the full 90 minutes, I think, to detail everything they've written. So that's why I didn't do that. But suffice it to say, I mean, we're really here very lucky to have the leading experts in their fields, and we're really grateful that they've come to Bloomington to be with us. So with that said, Becky, if you are ready to go, I'll turn it over to you. And like I say, probably at the 12-minute mark, you'll get a sign or a text or an email telling us you have about 3 minutes to go, okay? Thanks.
So thank you very much. I'm very disappointed not to be able to be there with you in person, but I'm happy that we can interact through the miracle of technology. If we could just go to that first slide, I'm going to bop through these in 12 minutes so that Jay doesn't shock me. Just to give you a little bit of background about myself and why I'm going to have a slightly different perspective perhaps than other people who will be speaking today. I did study lawyers for a very long time, and I still do, but I also study access to justice. So my interest these days in public interest and other kinds of lawyers is in the way they facilitate people's access to the rule of law and the legal system. So one thing we know, if you move to that first slide that starts about lawyers entering the profession, one thing we know is that most lawyers actually come to law wanting to serve the public in one way or the other. So that first bullet point on that slide points out that over 40 years of research into different law student populations, between a third and almost 3/4 say that they want to work in the public interest. That's what they say they want to do when they're in law school. And then if you move to that second bullet point, if you talk to lawyers who have left law school and are in practice, and you say, okay, think back to when you started law school, why did you want to do this? Most of them will say it's for some kind of pro-public reason. So they'll say they wanted to help individuals or change or improve society. So there's this enormous well within the profession, both at the level of students and then later when people come out and begin to practice, there's this enormous well of interest and commitment to serving the public. And then lawyers end up working for the public in a range of different ways. They engage with the public. If you move to the next slide, the first bullet point there is through community participation. So sometimes they do this just as regular citizens on the PTA. Sometimes they do it by sitting on boards and being other kinds of institutional leaders. If you move to that second bullet point, of course, lawyers engage in political activity. Some of them are running for president right now. They engage with politics in a range of other ways. And then finally, that third bullet point, some of them do work that is as part of their job that serves the public. And today, I'm sure that we'll talk a lot about classical public interest law, so cause lawyering of different kinds. Lawyers also work for the public by being public employees, by doing the public's legal work as employees of the government, and by doing direct legal service work for people. And whether we're thinking about public interest work or direct service legal work, some of that is pro bono work, that is the client's not paying, although the lawyer is sometimes paid. If you look at the pro bono activity of lawyers who are associates, for example, in big law firms, a lot of that pro bono activity is paid time for them, even though the organization or the individuals they're working for are not paying for the service. And then, of course, there's a lot of pro bono activity that's not compensated at all, particularly the pro bono activity of small practitioners who are serving the public as individuals. And then there are people who do this kind of work for a living. They actually, even if you think about public serving law or law in the public interest in a very broad way, if you move to the next slide that starts out who serves the public, what you see is that that's a minority of the profession. So if we think about classical public interest lawyers, they're somewhere between 1% and 2% of the profession. Whether you think of them as lawyers who work for cause organizations like the Sierra Club or the NAACP, or whether you expand that definition to look at private practice lawyers who say, I have a public interest practice. So I do commercial work part of the time, and then I do legal work for causes, I do impact litigation that's subsidized by that commercial work or funded in other ways the rest of the time. That's a really, really small proportion of the profession, and also a proportion of the profession that works for the public. Bigger chunks of lawyers who are doing things in the public interest work in government. So we have a judiciary. We then have all kinds of people at different levels of government who are doing our legal work as our employees, as public employees. There's another tiny sliver of the bar, around 1% again, that serves the public as legal aid and public defenders. And then there's a chunk of the bar that serves the public in private practice. And that's where most ordinary people, including ordinary people who are poor, get the legal services that they get. But the majority of the practicing bar does not work for the public in any of those senses. It works for business organizations. It either is an employee of those business organizations, or those business organizations are their clients in their private law firms. And my reason for putting classical public interest lawyers in this kind of broader context of lawyers who work for the public is that all of these different lawyers who work for the public turn out to have some similar challenges that they face in doing their work. And our answers to those challenges would benefit from thinking across this whole sector that I'm calling public serving lawyers. So one challenge that I'm sure the law students in the audience have thought about, and I know that the panelists have thought a great deal about, is the challenge of educational debt. So in our system, where law is a postgraduate degree, it's not really a 3-year program, it's a 7 to 8 year program. And 7 or 8 years of higher education in the U.S., where for the most part people are paying some or all of the cost of their education, is going to create fairly high debt levels. And so if you switch to the slide that is the graph of debt levels, what you see is that that nice little purple line with triangles on it was median debt for a sample of lawyers called after the JD. So this is a representative sample of people who became eligible to practice law around the year 2000. And what you see is that line is pretty flat. So no matter what kind of work you do, whether you're a public interest lawyer or you work in a big corporate law firm or you're in-house counsel, you have $70,000, $75,000 or so of debt at the median. What differs across these different settings, of course, is their starting salaries. And one thing that all public serving lawyers share, whether they're in public interest or legal services or government or small firm practice where ordinary people buy their legal services, is relatively low salaries. So even though everybody has fairly equal debt, those debt burdens are very different across different groups of lawyers. And if we switch to the next slide, we can see another picture of this from after the JD. So this is the ratio of educational debt to starting salary for lawyers who are serving different kinds of clients. And those lawyers far on the right that I'm calling others are the ones that are basically serving business organizations of different types. And they have the lowest debt levels because they have the highest salaries. But if you look at the lawyers who are serving individuals, whether that's in legal aid or public defense or in private practice, a good 60% of them have debt levels that are at least as large as their salary. You see a similar pattern if you look at lawyers who are serving the public by being public employees. About 60% of them have debt levels that are at least as large as their salary. And if you move to classical public interest lawyers, so lawyers who work for causes, and these are lawyers in the after the JD sample who either work for causes in classical public interest organizations, in cause organizations, or in public interest law firms, a whopping half of them have debt levels that are twice their starting salaries. So everybody comes out with debt, but they end up with very different debt burdens. And one question that has interested me in recent years is the supply of lawyers who can help the public. And so I began to wonder, how is it that people can bear these debt burdens? If you switch to the next slide, there's a familiar, although difficult to attach onto set of debt endurance, and that's loan repayment assistance programs. And there are lots of different kinds of these, and they keep getting proliferated in different ways. And the federal government now has essentially loan forgiveness programs that are essentially LRAPs. And some of them repay the loan, some of them forgive it, some of them make it easier to pay. Sometimes the money comes from law schools, sometimes it comes from the government, sometimes it comes from a bar association. The value of these things varies tremendously, and most of them have restrictions on how much you can earn or the kind of work you can do or the sort of organization that you're in and so on. So there are lots of different kinds of these things, but they're not widely accessible. But there's a second really important source of debt endurance, it turns out, and that's private subsidy. So there turns out to be an enormous private subsidy of public serving law, and this has implications for who's able to do this work, for the diversity of people who are staffing this part of the justice system. And the two kinds of private subsidy that I want to focus on today are what I call the family plans. So one thing you can do if you have a lot of debt is to marry somebody who makes enough money to help you pay it off. Another thing you can do if you have a lot of debt is to be fortunate enough to have parents who can help you pay it off. And these private subsidies turn out to be about as valuable as LRAPs if you're looking at what they allow people to endure. So if you move to the next slide, what this is an analysis that says, okay, let's look at the debt levels of people who start out in different kinds of public serving law jobs and don't drop out. So they endure the debt and the relatively low salary. How much additional debt is an LRAP worth? So if someone has an LRAP, they can carry $17,000 of additional debt and stay in public interest work. But if someone has a spouse who's able to help them pay off that educational debt, they can bear about as much, about $15,000. There's really not much difference between those two numbers. So the power of these private subsidies is on the order of LRAPs, at least if we're looking at what was going on with the sample of lawyers that were entering the profession at the beginning of this century. If you move to the next slide, we can kind of quickly review what impact taking these sources of subsidy away might have. So they have different impacts because different people have access to them. So loan repayment assistance programs were fairly rare. Not very many people have them, either then or now. But if we got rid of them, we might lose as many as 20% of the lawyers who start out in public interest and stay. And the big impact there would be on public interest lawyers, classical public interest lawyers, who have access to LRAPs at a greater level than many other settings of public serving work do. If we move to the second bullet point, you see that having parents who can help you out is also important, but also relatively rare. If we didn't have parental support, this particular private subsidy of public serving lawyering, we lose about an 11th of the folks who do this kind of work. And the biggest impact would again affect public interest lawyers. Now, this tells you something about the social class background of people who go into public interest. They are not a random sample of the bar. They tend to be a sample from more elite backgrounds. And that's something we might want to think about if we're thinking about what we want the bar to look like. If we go to that third bullet point, we can look at the spousal subsidies. Those are much more widely distributed. Of course, the last time I checked, even when we were talking about lawyers, male lawyers still make a lot more than female lawyers. So the people who have access to spousal subsidies that matter are often women who are married to higher earning husbands, and this also affects who's able to do public serving work. But if we got rid of these spousal subsidies, we lose maybe a tenth of the lawyers who stay, and nothing else changes, of course, of the lawyers who stay in this work. And the biggest impact would be on a different segment of the bar this time, on folks who serve individuals, either in legal aid or private practice, and then on folks who work for the government. So one of the things that Jay asked us to think about was how law schools might respond to some of the challenges that we identified. And if we move to the next slide, I just want to identify 3 things that I think law schools should do. The first bullet point on that slide is that law schools should validate a wider range of public serving law jobs than just classical public interest. So there's this enormous well of will to do good for people that comes into the profession, and there are just not enough public interest jobs to satisfy all the people who want to do that kind of work. Because those people, those organizations that would hire them have funding issues as well. So we ought to find better ways to help people channel their public serving interests into work that benefits the public in a range of ways. If you move to the second bullet point, this is related both to the range of public serving law jobs, but also to public interest law firms, that is, private practice firms that do work for the public interest as part of their mission. One thing that law schools can do to help those be founded and persist is to provide instructions to lawyers in how to actually practice law. which is different than how to read a case or make an argument about the rights and stuff like that. But how do you actually practice law, and how do you run a practice? That would be a valuable resource to lawyers across these different pieces of public serving legal work. And then the final thing that law schools can do, and I'm going to leave this open, but I do have some ideas about it, is they have to solve the problem of tuition. It is not sustainable that people come out of their legal education with $100,000 or $200,000 of educational debt, and there's not enough LRAP money in the world now, and there's not going to be enough loan forgiveness and LRAP money in the world in the future to deal with that problem. So that problem is something that law schools themselves have to tackle by rethinking the way they do what they do. Thank you very much.
Thank you guys for having me. I'm getting the echo here. Echo.
Sorry. Give me one more minute, if you don't mind. I'm going to do one quick thing so that she can see the slide. I'm going to try to. Oh, wait. I'm sorry. Oh, no, that just went away. I didn't. Oh, fine. Okay. I'm sorry you're not going to get to see the slides. Becky, I'm sorry. Go ahead.
Okay. Thank you. I come to you from Los Angeles, but I am a very proud Hoosier. My mom and dad both went to Indiana University, and I was born in West Lafayette. My dad, unfortunately, went astray for graduate school, but my heart is here in Bloomington. So it's really a thrill for me to be here for that reason, and also, of course, for the privilege of being able to speak on this panel with amazing colleagues whose work has really transformed the way I think about the subject for today, which is public interest lawyering in the U.S. and abroad, possibilities and limits. In my comments, I really want to focus on the idea of possibility, and I want to talk specifically about how public interest lawyers seize possibility in the hope of advancing social change that is both broad and enduring. While I know that other panelists will give a wide view of public interest lawyering both nationally and internationally, I want to take up the invitation to really contextualize some of the most innovative and perhaps least recognized work that public interest lawyers do in trying to move large-scale political and social reform. In doing this, I want to narrow the frame of analysis in two particular ways. First, I'd like to focus my talk on a particular type of public interest lawyer, who I will call the movement lawyer. And second, I want to focus on a particular application of movement lawyering at the local level in a place that I know well, Los Angeles. So I want to address four key questions associated with the movement lawyering idea. One is, what is it, and why has it achieved salience now? Second, what lessons can we learn from contemporary social movement campaigns? What are some of the legal barriers that these campaigns face, and what can law schools do to train lawyers interested in movement lawyering? In talking about the movement lawyer, I really mean to draw attention to a model of what legal scholars Lonnie Guinier and Gerald Torres have described as the, quote, public citizen who functions as a crucial source of moral authority and democratic legitimacy in facilitating the interaction between social movements and formal lawmaking. That is, movement lawyering, as I'm thinking about it, focuses on legal work that is explicitly conducted within the context of organized constituents who are mobilizing law and politics, often outside of formal institutional channels, to challenge the status quo. Although movement lawyering has a quite long history within the legal profession, the term has curiously reemerged as of late to describe the activity of lawyers, mostly on the political left, but also on the right, whose work is seen as coordinated with the aims of social movement actors. So why is this happening now? I think there's a larger story to tell, but my sense is that there are specific shifts in legal practice and legal theory that have brought the idea of movement lawyering to a more prominent role. The high-profile success of LGBT rights lawyers in achieving marriage equality and the Black Lives Matter movement prime among them. In legal theory, I also think that the idea of lawyers working collaboratively with organized movements with their own status and power promises to address long-standing concerns about lawyers dominating and derailing political struggles while still defining a meaningful role for lawyers in processes of transformative social change. So it's really this role that I want to explore today, and I want to do so by engaging with the idea of integrated advocacy, which is another sort of current buzzword within public interest practice that emphasizes 3 points. First, that lawyers are supposed to integrate their work with non-lawyer movement activists. Second, that in developing social change campaigns, lawyers are supposed to coordinate legal advocacy with other forms of political mobilization. And third, that lawyers should seek to influence decision makers in multiple lawmaking spaces. So courts in this model are important venues, but lawmaking also occurs in other places where lawyers do critical legal work, like legislatures, agencies, and even in the public forum and media. This leads me to want to explore how this advocacy actually operates in practice. And I've spent the past decade looking at my particular place, Los Angeles, and through that work I've produced a series of case studies on social movement campaigns, primarily coming out of the labor and immigrant rights movements, which have sought to address the problem of low-wage work through local government reform. And I would like to focus on one of these cases today, which I'm publishing as a book, as a vehicle to explore the movement lawyer's role. The case operates against the backdrop of what labor scholars have noted as a shift toward local lawmaking in a context in which solutions for labor problems at other levels of politics may be infeasible. So the city in this frame provides opportunities for social movement reform, but also imposes significant challenges. And particularly as social movement lawmaking is channeled to the local level in search of opportunity, it has to operate within a regulatory framework in which local powers are often constrained by federal power. And so a primary legal battleground of social movement-led local reform around these labor issues that I want to talk about is therefore around the doctrine of federal preemption. Now, the case study that I want to share with you is about how lawyers and social movement actors in Los Angeles sought to advance what I call the movement for green ports. So this is a map of Los Angeles, if anyone has ever had the occasion to look at it and wondered why there's a sort of the gray and yellow parts are LA and the white parts are not LA, why there's a bunch of gray and yellow and then a little tiny strip and then a gray at the bottom. It's because 100 years ago, city leaders decided it would be really good to annex the port, which is at the very bottom of the map, and so did so by a fiat of local government law. So I want to focus on the impact of this decision and the movement to make the ports better in ways that address environmental and economic justice concerns. So the movement was designed to push forward two big goals simultaneously: challenging low-wage work in a very important local industry, trucking, and challenging pollution at one of its biggest sources, the Port of Los Angeles. So what does movement lawyering look like, and what is it designed to do in this context? To answer this question, I want to give you a little bit of context about the campaign. The core legal problem that the campaign sought to address centered on the fact that port truckers were almost entirely designated as independent contractors, which meant that they were not employees of the trucking firms that bring goods into and out of the port complex. Instead, they were legally defined as self-employed, which meant and still means that they own or lease their own trucks, they pay their own costs, and significantly, they are barred from union organizing under U.S. antitrust law. For the labor movement, the legal problem was therefore quite clear in the campaign. The driver's independent contractor status prevented unionization. For the environmental movement, the issue was how this very same problem of independent contractor status contributed to air pollution. And here the story is fundamentally about explosive port growth. So together the Los Angeles and Long Beach ports, and Long Beach port sits right next to the LA port, are the largest port complex in the United States, one of the 10 largest in the world, accounting for roughly 40% of the goods coming into the United States. As cargo increased dramatically at the ports after trade liberalization and deregulation in the 1980s, which you see in the slide sort of peaking at around 9 million 20-foot equivalent units, TEUs, those containers you saw in the last picture, so did the number of trucks serving the port. So by 2000, there were roughly 16,000 drivers at the Los Angeles and Long Beach ports, and conditions were abysmal. A 2001 study found that on average these drivers earn less than $10 an hour, some much less because they bore their own costs and because of the amount of time they had to wait to pick up cargo. And here's where the labor problem really converged with the environmental problem. Because the drivers had to purchase and maintain their own trucks, they ended up buying very old ones through the secondary market after they had already been used by national fleet. So on average in 2000, The LA trucks were about 17 years old. Truckers earned too little to upgrade or to maintain them. So as a result, the fleet at this moment ran almost entirely on dirty diesel fuel. The trucks were highly polluting, affecting the health of the drivers and contributing to the overall air pollution in LA. So by early 2000, port-related smog coming mainly from trucks was the single biggest contributor to air pollution in the entire LA basin. So on the right is a map of air pollution put out in 2004 that modeled the cancer risk from air pollution in Los Angeles, and you see that the highest risk is really concentrated around the ports, which is that black area down at the southern part of the map. So at this moment, we see the port as a major economic engine for the city of LA, sitting on city land and run by a city department with regulatory authority over port affairs, subject to city council and mayoral approval. Now, here that the campaign enters to address the independent contractor status of the drivers, which is a thread that tied together three interconnected local problems. One was that it directly related to the low pay and poor working conditions of the drivers. Secondly, it was directly related to low quality trucks that were highly polluted. And third, it directly related to local community impact, since the drivers are driving through adjacent low income neighborhoods, parking their trucks in front of houses and abandoning their empty containers. It was and it remains a quite fascinating and ambitious campaign, which I'm happy to discuss in endless detail, but which I'm going to bypass here in the interest of time to focus really on the lawyering piece. And the first important point that I want to note is that it was environmental litigation over port expansion that was the lever that brought the city to the bargaining table. So confronted with the possibility of expensive and uncertain litigation, the city faced the threat that port clients would leave to the neighboring Long Beach port or even to Oakland or Seattle, and that threat really forced the city to develop a long-term policy solution to the pollution problem. This is the point at which the labor movement becomes involved in the story. The Teamsters had actually been thinking about how to solve the independent contractor problem for truckers for about 25 years, but could never crack it politically or legally. And when the NRDC, the Natural Resources Defense Council, won its environmental lawsuit against the port in 2004, Teamsters realized that a blue-green coalition, a labor environmental coalition, could be created around a problem of mutual interest. The campaign to challenge the situation really focused on persuasively making the interest convergence argument. I'm not going to go over the slide, but I wanted just to put it up there by showing the complexity of the regulatory environment that ended up in local policy change. And the interest convergence argument that labor and environmentalists made was that by changing the legal status of port truckers to employees, and thus forcing trucking companies to internalize the cost of their own business, the port could clean up pollution and thus stop the threat of disruption to its operations by environmental lawsuits. And here is where the law and the lawyering really come into view. The policy that the coalition proposed depended on convincing the city to mandate through city ordinance that trucking company access to the port be conditioned on a double conversion of truck drivers from independent contractors to employees, and of trucks from dirty diesel trucks to clean fuel trucks. And this the city was legally empowered to do because entry to the port was a type of contract between the city and the trucking firms that entered. And it was a very impressive campaign, brilliantly executed, that resulted in the passage of a local clean truck program that implemented this double conversion in 2008. I want to just highlight 3 points about the lawyering in some of the time I have left. First, that in a context in which policy development occurs in this complex regulatory environment, in which there are overlapping bodies of law that are implicated here, labor, environmental, transportation, local government, and when there's an increasingly specialized legal knowledge base, there have to be coordinated inputs across different kinds of advocacy sites by lawyers with different expertise and ideology. So not all of these lawyers that worked on the campaign were actually committed to the cause, but they were all necessary to achieve it. The second point I want to make about the lawyering is that one of the most important things that the lawyers did in this campaign was to conduct legal analysis about the validity of the Clean Truck program that made predictive judgments about how courts would rule on the issue of preemption, and to mobilize those judgments in different policy spaces to persuade key decision makers, both city officials and city attorneys, to sign off on the ultimate policy proposal. So, of course, there were lots of political work involved to persuade the mayor and the city council here, but it was striking when I did the research to learn how important the legal opinion that the lawyers did on preemption was precisely because of the local political calculation. Officials wanted to put in the effort to pass this law only if they thought it would ultimately bear fruit and not get derailed by litigation. So it's here that you see these lawyers advocating in different lawmaking sites. They were working within the Port Department, the Board of Harbor Commissioners that set port policy, City Council. They were interacting with city attorneys representing the port who had to be brought on board and sign off on the ultimate policy, as did the mayor's general counsel. And again, you see lawyers that are really coming from different places and different disciplines. You have lawyers from the Natural Resource Defense Council working on policy development and grassroots organizing. You have lawyers who are in these small private public interest law firms that focus on labor and land use, really working to make sure that the policy is crafted from an appropriately valid legal point of view. And the final point I want to make is that at the end of all this legal work outside of court, litigation still loomed. So despite the effort to keep this within the local policy-making domain and out of court, passage of this Clean Truck program in 2008 meant that the legal battle had really just begun. The industry swiftly challenged the program on the ground that it was, in fact, preempted by a quite obscure federal law which prohibits localities from regulating the price, route, or service of motor carriers. And this is back to the point about predictive legal judgment. The coalition and the lawyers expected this lawsuit to come. Their lawyers, both on the environmental and the labor side, had done their legal homework, yet they expected that they were going to win. What they did not expect was precisely what the industry would do in its legal strategy. I said that the policy required trucking firms to effectuate this double conversion of the environmental status and the labor status of the trucks. Industry really only challenged on the labor conversion, the piece that converted the drivers from independent contractors to employees. It left the ban on dirty trucks in place and even said that it welcomed it. And the result of that decision by industry was really to split off the legal interests of the coalition members, the environmentalists from labor, and to frame the legal issue in court in a way that highlighted the labor piece of the policy, which was both most central and most legally vulnerable. So the case went up and down to the Ninth Circuit 3 times. It ultimately went to the United States Supreme Court, though on grounds not related to the labor issue. And the Ninth Circuit held that because labor conversion was not centrally related to the port's interest as a market participant in controlling pollution, it was preempted. So the coalition, which had fought so hard to keep this fight local and develop local policy where they could win, ended up losing in court on federal grounds. And one more slide, and then I'll turn it back over to the other folks. And I wanted to wrap up and think about some of the barriers to regulation of these that make these kind of campaigns quite difficult to win, and to think about the lessons to draw for lawyering. One is, I just want to underscore the point that this is incredibly complex and difficult work that's made difficult precisely because the law as it currently stands is set against the movement's goals. So in thinking about barriers of this kind of movement work, one can mark the precise contours of how existing regulation makes progress very hard to achieve. So first, as there are, as I've described, basic barriers to equity and fairness that are enabled by established principles of corporate antitrust and labor law. So the idea that trucking firms may establish themselves as separate legal entities distinct from truck drivers who they treat as independent owners in their own right and with whom they purport to contract at arm's length, thus separating themselves, the trucking firms that is, from legal liability for drivers' wages and environmental compliance, though all the while dictating the precise terms of drivers' work. This legal fiction operates to bar collective action by the drivers themselves, who are legally cast as their own companies, who cannot organize for improved conditions without violating antitrust laws, prohibition on combinations, and restraint of trade. So in this way, the formal naming of drivers as contractors, not employees, a designation, by the way, that most of them resist, places them in a legal box where they have none of the freedom and benefits of entrepreneurship, but all of its costs. The second barrier in the framework is the doctrine of preemption, and I just want to mark that it's a unique type of preemption. The campaign I described tried to get drivers out of the first box by creating a local policy that would transform them back into employees. But this was struck down under a preemption theory based on claimed commitment to an absence of law. So it was a prohibition against local trucking law mandated by federal deregulation, now used as a basis for preemption. So this is not preemption because of an affirmative regulatory scheme like labor or environmental law occupying the space, but because of the withdrawal of legal regulation and a proscription against localities setting rules affecting price, route, or service. And the third and final lesson just goes to the differential power of the legal tools that are used to mount campaigns that are designed to restructure the legal framework of industries like port trucking in the face of this preemption threat. So what organized labor sought to do in this case was legally complex and ambitious, again, changing the legal framework governing a particular form of work by leveraging the city's contracting power to move drivers from one status, independent contractors, to another, employees. So the idea was really to use local government law to restructure employment law. Yet the primary frame for doing this was anti-pollution, right? Convert drivers to clean the port. And the primary tool was environmental law. It was a litigation threat under a relatively robust environmental framework that both forced the policy negotiation and critically formed the basis for the exception to preemption under which the city authorized the program, specifically that it was the city's interest as a market participant in the transportation industry to clean up the air and thus avoid risk to expansion that really justified the clean truck program. But environmental cleanup as a legal frame and a legal tool ultimately left too little space for labor's goal of employee conversion, which the courts found too tenuously connected with the goal of going green. So the lesson, I think, is to underscore really the structural weakness of having to use these alternative legal frameworks like environmental law to advance affirmative labor reform in a context in which labor law itself is a barrier to organizing and change. I didn't want to end on a sour note like that, and I had some ideas about what legal education could do. Fortunately, they basically map onto the ideas that you just heard from Becky Sandefur, so I will end there, and thank you very much for your attention.
I am thrilled to be part of this event and enormously grateful to Jay and Ethan for organizing the conversation and including me in the participants, the panel. I'm also extremely grateful to them for supplying a definition of public interest law for us to use in preparing for the conference. I'll spend my allotted time talking about how this definition relates to the three questions that our hosts have asked us to consider. Those questions are about what public interest lawyers are contributing, what constraints impede their work, and what law schools are doing and should be doing to promote entry into public interest law. Jay and Ethan have defined public interest law for purposes of this event as follows: as public, private, pro bono, and for-profit legal services providers devoted to a social cause or advancing the rights of vulnerable populations. Notice that this definition includes not only lawyers who serve the poor and otherwise vulnerable populations, but also a broader category of those who serve causes. Notice, too, that it includes lawyers in all practice sectors, not just those in nonprofit organizations. The issue of what constitutes public interest law has been the source of a great deal of controversy over the last 4 decades. Arriving at a coherent definition has proven to be an interesting challenge for those of us who study the institutions and lawyers associated with this malleable concept, and I believe it is one that has confounded or at least challenged everyone on this panel. But the definitional issues are not just an obstacle for researchers. Competing definitions are also a source of disagreement and contention among advocates themselves, and they are bound up with public policy controversies and competition for the high ground in those debates. The first wave of public interest lawyers in the early 70s may have agreed as to how to define public interest law, what constituencies it should serve, and what policies it should advance. But those questions are now deeply contested. Organizations ranging all over the political spectrum have emerged and declared themselves public interest law groups. Today, lawyers on opposite sides of all the divisive public policy issues of our times fight one another under the banner of public interest law. Other scholars, I think it's worth noting, have offered definitions of public interest law that are somewhat different than the ones suggested here by Jay and Ethan. Scott, for example, has staked out a definition tied to a progressive vision. I tend to take a more sociological approach to these questions. So I'm agnostic about how to define the term public interest law, not because I don't think there are some types of causes more worthy than others, and not because I don't think that the rhetorical battle matters in terms of the politics of the profession or politics writ large, but rather because I find it difficult to imagine ever reaching a consensus on a definition. Before I try to respond to the three questions that the organizers have invited us to consider, I want to explain my general orientation toward those questions. The theme of the symposium or the event is the limits and possibilities of public interest law, and implicit in the title and in the questions posed for our consideration is that public interest law and public interest lawyers are good, and that that law schools should seek to promote them. And I share the organizers' enthusiasm and optimism about how lawyers can contribute to justice and positive social change. I also see great value in helping law students and lawyers find meaning and satisfaction in their work by aligning their values and their political commitments with their professional pursuits. But I'll also express a few notes of caution about the call to action implicit in the themes of this event. The first question posed by our host is about what public interest lawyers are contributing. Scott, Becky, and Ben, I think, have more to say than I about the particular contributions of lawyers who fall within the second part of the definition of public interest lawyers, that is, those who serve vulnerable populations. As Jay indicated, I did do some substantial research in the 90s on civil rights and poverty lawyers, but my findings, I have to confess, I think are dated now. With respect to the first part of the definition, lawyers serving causes, I don't even know where to begin in cataloging the contributions of these lawyers. A large body of empirical research on lawyers devoted to causes finds these lawyers everywhere, working on a huge range of issues in all the arenas where law is made and negotiated. So, for example, lawyers are involved in advocacy relating to environmental policy, consumer protection, labor issues, guns, property rights, gender equality, employment, immigration, disability rights, human rights, LGBT rights, education policy, affirmative action, criminal procedure, police practices, government surveillance, homelessness, religious freedom, civil liberties, racial justice, and campaign finance, which is the subject of my current research. And lawyers play many different types of roles with respect to all of these issues, including litigating in federal and state courts, lobbying, legislative advocacy, rulemaking, media relations, public education, and community organizing. But the point I think bears emphasis is that as the term is defined here, there are scores of public interest lawyers on all sides of these issues. And one's views about the merits of the controversies and about which side offers the more compelling vision of the public interest may determine how enthusiastically one embraces the work of these lawyers and their contributions, and the contributions they're making to social change. Each of us may find ourselves rooting for some public interest lawyers and against others. You and I might not always agree about which groups and lawyers are making positive contributions rather than socially harmful ones. As to the second question about what constraints stymie the work of public interest lawyers, I think the most obvious answer, and the one we've all referred to so far, relates to funding. Money is an essential ingredient for all types of public interest lawyering. Empirical studies, including Becky's excellent work on how civil legal aid is organized around the country, Katie Alveston and Laura Beth Nielsen's research on public interest law groups, and other research reveals vast differences in the resources available to the organizations that engage in public interest work in the U.S. Some groups and lawyers receive major financial backing, sometimes from private sources, while others limp along on shoestring budgets. Becky's work also helps us appreciate that there are constraints other than financial resources that impede the exercise of legal rights, including how people understand their problems and whether they even conceive of them as legal problems. And Becky's work also raises important questions about whether the legal representation models generally favored by lawyers, that is, models in which lawyers play leading roles, are always the most effective means for addressing systemic issues relating to poverty and inequality. The third question posed by Jay and Ethan is about what law schools should do to promote students' entry into public interest law. And since one finds calls lawyers on both sides of all the major public policy controversies of our time, and some of these lawyers, in my view, are on the wrong side of issues I care about, I confess that I have somewhat mixed feelings about the generalized goal of sending cause lawyers in the world without specifying what causes we're talking about. But I wholeheartedly embrace the goal of encouraging graduates to serve vulnerable populations, and scholarships and loan forgiveness programs help to counteract the disincentives, the financial disincentives to pursuing such work. And Becky points out that law schools might also undertake a campaign to get our students to be born into wealthy families and to marry people of means. The definition of public interest law provided by our hosts also invites us, though, to consider how lawyers in many different types of practice settings can serve vulnerable populations and important social causes. A very high proportion of the students who come to my law school, UC Irvine, express strong interest in engaging in public interest work and in public service. But of course, it's very difficult to land public interest jobs in the nonprofit sector. Those positions are rare and the competition for them is fierce. So law schools can do students a great service, I think, by helping them imagine other ways by which to have impact on the issues they care about. At UC Irvine, where I teach, we require all first-year students to take a 4-unit course designed to educate them broadly about the legal profession. Roughly half of the course is devoted to a survey of various practice settings in which lawyers work, including criminal defense and prosecution, other government interests, other government positions, large firms, in-house counsel departments, small firms and solo practice, boutiques, legal services organizations, and cause-oriented nonprofit organizations. I know that Indiana has a course with similar purposes, and in fact, my conversations with Bill Henderson around the time of the founding of UC Irvine Law School in 2008 were a major source of inspiration for our course at UCI, so I'm very grateful to Bill for talking with me then. Much of what our students learn in the legal profession course relates to what the work and practice organizations look like, incentive structures, and legal and ethical issues that lawyers encounter in each of those practice settings. But the course also highlights how some lawyers in all practice settings find opportunities to serve especially deserving clients and causes they believe in. Another of the reasons that I like very much how our hosts have framed today's conversation is that it encourages us to think broadly about lawyers' relationship to the public interest. This approach is consistent with my long-held view that law schools have an obligation to encourage all students, whatever practice setting they plan to enter, to be reflective about their responsibilities as lawyers and as citizens for the quality of our justice system. I was reflecting on this question just yesterday while talking with one of my students about his interview with a retired state attorney general who spoke passionately about a series of recent shocking examples of prosecutorial misconduct and the failure of those prosecutors to honor their duty to do justice. The former prosecutor advocated requiring all first-year law students to take a course called something like Justice in America, the purpose of which would be to impress upon students the consequences of how we structure our legal system, the consequences of how we distribute legal services, and the consequences of how lawyers conduct themselves in their daily practices. I'm not sure that I would support his particular proposal, but I agree very much with the sentiment behind it. So in my first-year legal profession course, I urge students to see the relevance of these issues for lawyers in every practice sector, because I think it's well worth reminding our students that the responsibility for the quality of our justice system lies with all lawyers and indeed all citizens, and that we cannot delegate the important responsibility for this to a specialized sector of the bar called public interest lawyers. Thank you.
Good afternoon. Let me echo my fellow panelists in saying it's a delight and an honor to be here. I also want to say thank you to Jay and Ethan for also sort of giving me the opportunity, or maybe pushing me to rethink some of the work I did on public interest law in China. Most of the work I did on this in China was 15 or more years ago, and as you'll soon hear from me, at a time in which I think things were a little bit more optimistic with regard to the possibilities for public interest lawyering in China. So the prior panelists have sort of outlined a number of challenges we face in talking about public interest lawyering in this country. Challenges of finances, of money, challenges of complex legal frameworks and legal strategies, challenges of definitions. When it comes to China, I'm going to talk about a different type of challenge. That's the challenge of survival. Survival both in terms of institutional survival. Can particular public interest institutions survive, but also survival in terms of individual freedom? Can particular lawyers stay out of jail, which unfortunately is the question that is really central to many public interest lawyers in China today. All right, so over the past decade, one phrase has really come to dominate discussion of the Chinese economy. This is intentional. I'm not giving you the wrong lecture about the economy instead of lawyers. And that phrase is 国进民退. The state sector advances while the private sector retreats. Right? This is in talking about the economy in the 90s. There was a sense that China was privatizing, moving towards a market economy. In the 2000s, what we found was the state sector really reestablished itself, and the state came to dominate the economy once again. So what I want to suggest this afternoon is that the same phrase can be used to describe public interest law in China in the 2000s and in the 2010s. The state has advanced while space for non-state actors has been severely restricted. Public interest lawyering, as I'm going to talk about, is possible in China today, but it's less possible than it was a decade ago. It's most feasible when the goals of public interest advocacy align with or directly support those of the Chinese Communist Party state, and when Chinese public interest advocates are not seen as tied to foreign funders or organizations. And just keep this in mind as we go forward, because I think the single biggest change we've seen perhaps in the entire public interest sphere in China over the last 15 or 20 years has been the change from really welcoming foreign funding to being deeply suspicious of it. All right, so let me just start out by trying to answer what it means to be a public interest lawyer in China. It's actually not easy to do. To think about what the public interest in China is difficult in a system in which the official narrative is that the public interest is one and the same as the interests of the Communist Party. So to do this, let me just give you a little bit of historical background. We just heard that public interest lawyering in the U.S. really starts in the late 60s, early 70s. In China, the concept of public interest lawyering didn't really exist at all until the mid-1990s. When I started doing research on this, I'd go around and say I'm doing research on, legal aid, or something, and people had no idea what I was talking about. It's 95 or 96. And so we've come a long way since then. But it's important also to remember that until the early 1980s, China had very, very few lawyers. Today it has the third largest legal profession in the world. And until the early 1990s, virtually all lawyers in China remain state employees. Today, very few lawyers are actually employed by the state. Now, the earliest efforts in building up public interest lawyering in China started in the mid-90s, and these were largely university-based and almost entirely foreign-funded, initially by the Ford Foundation, later on by other international donors. Examples of these public interest organizations included the Women's Rights Center at Peking University, the Environmental Rights Clinic at China University of Political Science and Law, one of your partners here in Indiana, and the Center for Rights and Protection of the Disadvantaged at Wuhan University. In the late 90s, early 2000s, numerous universities likewise set up legal aid programs and in some cases, legal aid clinics, often partnering with American law schools, later on with European law schools as well. At the same time, the university-based programs were enjoying significant space in which to operate. The state, through the Ministry of Justice and lower-level justice bureaus, also began to provide legal aid. Today, China, to its credit, I think, has thousands of legal aid offices run by local justice bureaus. Some of these employ full-time lawyers to staff cases, but the overwhelming majority of these operate basically by having full-time employees who farm cases out to local lawyers who perform this legal aid work as part of their mandatory pro bono requirements. So China mandates pro bono work by all lawyers. We can talk about how well that's actually enforced, but it does actually have mandatory pro bono requirements. So the result is that the state plays a primary role in determining what is public interest law in China. There's actually very little pro bono work outside the state system, although as I was listening to some of the prior panelists talk, I was also thinking, well, actually, there's a lot of informal pro bono in China, right? People do a lot of legal aid work, either low bono or pro bono work for friends, for family, for people from their hometowns. So there is other work that goes on, but most of what goes on in the pro bono sphere in China is actually made up of cases assigned by the state to lawyers. And most of these cases are routine. We can discuss later, we've talked about it a little bit, whether lawyers handling these cases can be said to be engaged in public interest lawyering. But the Ministry of Justice certainly uses the language of public interest lawyering to describe these efforts, and other state entities, official trade unions, official women's organizations also have set up legal aid offices doing similar work. All right. So this is the backdrop. Right? The early 2000s saw two really significant developments in public interest lawyering. First, were the creation and establishment of a set of legal NGOs focused on specific issues: labor rights, the rights of children and migrant workers, more recently groups working on environmental issues, LGBT rights, mental health rights. These are closer to what we might think of as pure NGOs, operating independent of both the state and of universities. And many of these also rely on foreign funding and foreign donors, but some of these NGOs have drawn significant financial support from within China. A second group of public interest lawyers to emerge, I think really starting in the early 2000s, were the rights lawyers, Wei Quan, Liu Shi. And these are individuals explicitly using legal strategies to advance rights-based claims, and I think these are people who are closer to the social movement lawyers we've heard about in other jurisdictions. So the range of cases taken on by rights lawyers has varied enormously. I'll just mention, if anyone's interested, you should read the book on this by Ava Peels at King's College London, who's done really outstanding work on this group of lawyers. But rights lawyers have often taken on what are clearly politically sensitive cases, representing Falun Gong adherents, representing Christians who are being persecuted and prosecuted, representing political dissidents, bringing suit to demand greater government transparency, or representing lawyers who themselves are being prosecuted for offending often local interest. But as we talk about this, in a minute as I talk about the backlash against rights lawyers, it's also important to remember that this concept, this term rights lawyers, really only developed in the 2000s, and the growth of a defined group of lawyers who we can think of as rights lawyers is itself a manifestation of there being more space to navigate in the Chinese system. Right? In the 90s, in the 80s, no one was talking about there really being a group of human rights lawyers in China because it really wasn't possible. Now, some would say that, just as the term didn't exist in the 90s, maybe it almost doesn't exist today, as we've seen a big crackdown on this group of lawyers in the last few years, and something I'll come back to in a minute as well. But in the last few years, we've seen a very large number of detentions and, in some cases, prosecutions of this group of lawyers. Right, so as I just hinted at, over the last 5 to 7 years, we've seen a significant tightening of control over most public interest lawyers. Numerous rights lawyers have been jailed, including many who were previously understood to be operating within the limits of what is politically possible. University-based clinics have been closed or face new restrictions on the cases they may bring or on the sources of funding they may accept. Some prominent NGOs have been disbanded. At the same time, the party state has moved to take on a greater role in what it defines as public interest lawyering. This is done both by government legal aid clinics, but also by legal aid programs run by traditional trade unions and other party organizations, and also through procuratoriates, which are both the prosecution, but also have a role in civil cases in China, bringing suits in the public interest and claiming the mantle of representing the public interest. But that said, some important NGOs have persevered and continue to engage, albeit very carefully, in very important public interest work. All right, so let me spend the rest of my time directly addressing the challenges facing public interest lawyers in China today. And let me do this by addressing 5 questions that I think are central to understanding the practice of public interest law in China today. 5 questions, 5 minutes. All right. Luckily, I'm from New York, so I can speak very quickly. All right. First, and maybe I'll get some leniency over here from Professor Michelson. All right. First, what distinguishes those lawyers who are able to continue to operate from those organizations that have been shut or individuals who have been jailed? Let me just highlight quickly 2 things here, right? So there's one set of people who have survived by maintaining really close links to the party state, in some cases by actually serving in local government, by having official party roles or government roles. So there's a set of lawyers who have been very successful by really defining themselves as working within the system. And this is not by any means to denigrate or to disvalue the work they do. These people are doing really important work, but they figured out a way to do this work partially because they're political insiders in the system. But there's a second set of strategies that others have followed, which is just the strategy of being really, really careful, right? We've seen non-political insiders working in areas as diverse as mental health rights, LGBT rights, labor rights, surviving mainly by being really careful about their tactics, right? Choosing cases carefully, not engaging in direct challenges to the party state, choosing also the time at which they bring cases very carefully, right? So different times are varying their political sensitivity. So, and I can come back to this later on if there are more interest, right? That's question 1. That was more than a minute. All right, question 2. What is out off limits? Let me just here say maybe quickly, what is the line between what is off limits and what's on limits, and what distinguishes those who survive from those who wind up closed down or in detention? Some would say that the difference here is a difference of tactics, right? That people who are more confrontational are more likely to run into problems. And certainly that we look at people who've been detained over the past few years, it's not just the sensitivity of the cases they've chosen, but it's the sensitivity of the tactics they've pursued. People who've tried to engage in network building, street-based advocacy, links to broader social justice issues. These are people who've run into more problems. Explains, for example, I think in part, the detention of 5 women's rights activists last spring. I also think there's a lot more attention now to sources of funding, right? The Chinese party state's much more careful and much more wary of people being funded by foreign governments or by international organizations. But the real answer to this question is that we don't know. And that this is by design, right? That part of the strategy of regulating lawyers in China is never to make clear what that line is, with the consequence, of course, being that people move away from that line. So everyone is now more careful. And it's also important to remember that the Communist Party is not monolithic. In many recent cases of crackdowns or detentions of lawyers, we have actually no idea which arm or level of the party state was responsible for the decision to detain or prosecute. So we don't know if this is coming from the center or from the local level. All right. Third, what strategies are most effective? Let me just abridge this by saying that the strategies that are most effective in China when it comes to public interest advocacy are almost never strategies that rely on court decisions, right? So public interest lawyers can be effective in China, and they can be effective in individual cases, but broader change never comes from a court decision, right? It comes from activists working together, often working with the official media, raising awareness of issues, but they're not relying on court decisions to bring change. Courts can serve as fora in which claims get raised, but on issues of legal or social policy, courts are not the key decision makers in this system. Fourth, what are we missing by focusing on the work being done by public interest lawyers in China? And here I just want to point out that a lot of what might be public interest cases in the U.S. and other jurisdictions never make it to court in China, right? So if you look at some of the really high-profile disasters in recent years in China, the melamine poisoning in milk in 2008 or the Tianjin explosions last summer in August, right? These are cases that by definition never get into the system. The authorities step in, they buy off, or they forcibly, in some cases, buy off the victims, and they explicitly tell lawyers not to get involved. Lawyers are not allowed to take on these cases, and courts are not allowed to bring these cases. So there's a whole range of cases which might be, think about the Gulf oil spill here, and the litigation that's come out of that. That type of case just doesn't occur in China. These cases are not allowed to be brought into the formal legal system. And sometimes even more routine disputes are kept out of the legal system. If we look at areas like medical malpractice, a lot of what's going on right now is the creation of mediation institutions, alternative dispute resolution institutions, which I think, this is contested by many in China, I should say, which I think are designed in part to keep cases out of courts and are designed in part to keep lawyers from getting involved in these cases, right? Because mediation in China often explicitly excludes lawyers. And then fifth, what does all this mean for the overwhelming majority of Chinese lawyers who are doing the routine work of lawyering? These are the commercial lawyers we saw in the first presentation that Becky gave us. People operating in the private, not the public interest sphere. And here I just want to highlight two trends, which is, one is that I think there is increasingly a lot of cross-identification. So 15, 20 years ago, I don't think lawyers who were doing ordinary work identified with public interest lawyers. Today, I think they do, and I think they do actually most often in cases in which lawyers are being politically persecuted. So if we look at, for example, the most high-profile prosecution in the last few years, prosecution of Pu Zhiqiang, probably one of China's most well-known activist lawyers, who was prosecuted prosecuted last year, a sentence came out early this year, pretty obviously absurd charges, right? He's prosecuted for 7 sentences posted on WeChat. What was most interesting about this case was the degree of backlash it generated against ordinary lawyers in China. I was in China 3 times in the fall and winter. Every lawyer in China was aware of this case, and they were talking about it, and they were upset about it. In many cases, they were posting about it, and that's a change. So this starts a few years ago with the famous Li Zhuang case, but today I think when lawyers come under assault, ordinary lawyers, even if they don't get involved, I think to some degree self-identify with lawyers who are being persecuted as well, in a way in which they didn't in the past. It varies when we talk about this as well. And this is linked to the second trend I think is worth watching in China, which is harder to prove, but is that I think there is a general sense among lawyers today in China that they are viewed with increased suspicion by the party state. And we see this in greater emphasis on ideological control over lawyers, all lawyers in China, and in some local efforts to restrict lawyers, sometimes somewhat absurdly. For example, the Justice Bureau in Chengdu in the fall issued a notice saying that all lawyers in Chengdu had to register with the Justice Bureau or the Lawyers Association anytime they wanted to go overseas, right? This is actually illegal. There's no legal basis for this. They don't have that authority. I know it was widely mocked by lawyers, but I think it is representative of an effort to tighten general regulation over lawyers, not just over those engaged that we might think of as public interest or advocacy or activist roles. And I think that part of this story here may be a knock-on effect in terms of how the party state views, knock-on effect from what went on in the 2000s with the rise of rights activists. I think that with the rise of rights advocacy in China, especially by lawyers, there was some pushback from the party state and growing suspicion of all lawyers. So there's a tiny number of actual rights activist lawyers in China, but to some degree, their work has had consequences for how the state views lawyer more generally. But I also think part of what's going on here is the state has become well aware of the role that lawyers have played in fostering political change in many other jurisdictions. All right, I had one more point I was going to make, which is to sort of link this to legal reform more generally in China. And I don't know if I'm allowed to make my last final point, or should I be quiet because we only have 10 minutes left? Let me stop and just say, I think there are really interesting parallels to legal reform in China generally, where the most important trends are serious reform and serious repression going on at the same time. With that, let me stop.
Well, thank you, everybody. I just wanted to say very briefly before opening this up to the floor for questions, comments, I wanted to just say that it's been a real privilege planning this event with Jay. I wanted to thank all the panelists who traveled from very long distances to be here in the flesh and blood, as well as Becky for being here in pixel form. So in the interest of time, I'll just ask one very quick question, and that's actually for Becky. I'm curious, you mentioned the various, can you hear me, Becky? Okay, excellent. So you mentioned the various sources of funding, right? You mentioned the LRAPs, you mentioned the family plan, right? Family money from parents, from spouses. But I didn't hear you talk a lot about scholarships. And I'm wondering if what we know about a relationship, if any, between students who are funded with law school scholarships and what they end up doing, their areas of practice after they graduate. Does this increase their tolerance for low incomes in public interest practice and create, you mentioned the overrepresentation in public interest law of people from elite backgrounds. Does this also create an overrepresentation in public interest law of people with talent, right, who qualify for scholarships? So that's my question. And I also wanted to make just a quick comment on the issue of pro bono, kind of a weak culture of pro bono work in the Chinese context. Viewed another way, if we expand the definition of pro bono to include what Bert Kritzer calls de facto pro bono, right? When you can't collect your fee, so you're not paid when the client refuses to pay you, then China arguably has the largest pro bono bar in the entire world. So taking something depressing and making it even more depressing.
So Becky, yeah. Becky, are you talking? Okay.
That was a really good question. And actually, two of the best people to answer that question are on the panel, because they're both institutions that are trying innovative models of essentially providing scholarships for legal education to see how that changes the career outcomes of the attorneys that come out of those programs. So Irvine did this wild thing where you have entire classes that pay no tuition and then they step that down. And I know that they are studying the outcomes of that. And I know that Scott, with Rick Abel and some others, is involved in a study of the public interest law program at UCLA. And this is a big way of also saying I don't know myself the impact of scholarships, but I would love to hear from Ann and Scott about what they're learning about the cool things that are going on at their institutions.
I don't have systematic data on what UCI's results have been. Our first-year class received full funding for 3 years, and many of them went off to do very interesting things in public service and public interest work. And I know we are studying in a more systematic way what our graduates are doing and trying to tie those outcomes to issues of funding. But I don't have the data to share. I'm sorry.
Yeah, we're also in the process of data collection. We're asking students specifically about the receipt of scholarships and then tracking their career paths for 10 years. So we'll be able to say something about that, but right now I can't.
Say again, Becky.
No one knows.
No one knows.
But a good question.
Tell us in 5 years.
Yeah, at least something more.
The floor is open. And please, when you ask your question or make your comment, speak into the microphone so Professor Sandefur can hear you.
Hi, thank you all for being here today. There's some scholarship suggesting that legal action without being paired with activism doesn't actually further the goals of maybe a public interest lawyer or a public interest movement, and actually can have the effect, the opposite effect. A couple of examples are Brown versus Board of Education, where this was, a Supreme Court decision desegregating schools in the United States, but in response, states passed rules that changed busing routes that kept schools effectively segregated for decades to come. Another example, I forget the name of the case, is the Supreme Court of Hawaii case where someone granted a gay couple a marriage license, and that kind of prompted the Defense of Marriage Act constitutional amendments in a huge number of states. Do you think, I guess, that the law alone is enough to affect social change, or do you think that it needs to be coupled with activism changing people's minds about these topics as well?
I mean, my own view is that it absolutely has to be coupled with other kinds of political activism to try to change people's minds. I think the studies that you cite may do a disservice to the power of law to change people's minds, and I think there are lots of people who have strong disagreements about whether or not legal opinions can shape people's attitudes in positive or negative ways, and there's different sort of empirical evidence on that particular score. But I think that if you ask lawyers who are on the ground doing this work now what they think is most effective and how they think about the work that they're doing, they're absolutely figuring out how to try to coordinate their legal strategies with these other efforts to try to move policy in different spheres and change people's opinion through public relations, and I think that's absolutely critical. I mean, one of the points that I wanted to make in my broader project about movement lawyering is that I think people are interested in the concept now of movement lawyering precisely because it responds to the critique that you just identified, which is the idea that these lawyers are actually embedded in these movements. The movements are sort of calling the shots and trying to figure out how to produce sustainable change and change people's hearts and minds over time. And lawyers are helping out in that, but they're not driving the bus. And I think that idea is one that's been around a long time, but people are attending to it now precisely because of these critiques that are out there and trying to figure out how to respond to them.
I agree completely. I mean, this idea, there was this critique that came out in the 70s about the myth of rights, lawyers who think that judicial declarations will transform society. And my own sense is that savvy public interest lawyers for a long time, not just recently, have been attuned to the importance of thinking really strategically about different strategies and how they interact with one another, and that in most circumstances it requires a coordinated strategy to actually yield good outcomes.
Hi, thank you all. This was a really interesting panel. I'm a PhD student in sociology, so none of this has implications for my career necessarily, so I really enjoyed it. My work is on Russia, and my question is for Professor Liebman. Now, in the Russian context, there's some evidence of lawyers distancing themselves from the profession in order to perform some advocacy work, particularly in an NGO setting where the work they're doing might be politically contentious. And given what you shared about the trends in China over the past 20 years, I'm wondering if there's anything to suggest that that might be the case there, if not now, then at some point, where if lawyers are being targeted in some way, will they start distancing themselves and still perform the work of lawyering, but not call it by that name?
It's a great question. Actually, all right, it actually links a little bit to the prior question, because when you asked the prior question, I was thinking, maybe in China the reverse is the question, right? Can you have effective social change working on certain issues, but without being a lawyer, right? And so maybe in the present situation, if you're really serious about environmental rights, what you want to do in China is be an environmental NGO, there are hundreds of them in China, but not do legal work because the legal work is seen more sensitive. And certainly in China we have seen certain NGOs doing quasi-legal work but not calling themselves lawyers, right? People who are legally trained but not having a law license doing this work, and China lets you appear in court without having a law license, at least in the civil side. There's now some more restrictions. And part of that was just it's much harder to register as a legal NGO than it is to register as a regular NGO. And so I think absolutely we've seen people do this. That said, I think that some of the groups that have run into trouble precisely because they've moved from just doing, say, ordinary cases to actually doing broader social activism. And I think that's where the authorities have gotten really worried. Part of this is network building, as I talked about before, cross jurisdiction, across the country. Part of this is also just moving from just doing routine cases to doing more activists. But I think absolutely, I think that in an era in which cause lawyering or activist lawyering is seen with incredible suspicion, it is still possible to be an NGO doing more routine NGO work, and that may be a safer space.
And thank you very much for being here. I also have a question for Professor Liebman. And I just want to know, do you think whether the recent judicial reforms in China will increase or decrease the chance of the survival of those public right interested lawyers in China? And also, I noticed that recently President Xi Jinping and several top-level political leaders held meetings with those public rights lawyers, I think, or representatives of them, and also some legal scholars talking about how to, well, the topic may be about the regulation of those lawyers. I don't know. What's your opinion about those high-level conferences? Thanks.
So, great questions. I wish I could have been invited to those meetings as well. Although they've been detailed. On the first point's a huge question, right? So China now is engaging in the most significant legal reforms we've seen in a generation, 20, 30 years. Massive reforms going on in the courts, and this gives me an opportunity to finish what I was going to say, which is that just say that I think what's going on right now in China is fascinating, exactly because there's a really serious effort to do legal reform, and there's a lot of repression. I think that here in the U.S., the narrative we tend to get, especially from our media, is because they're locking up lawyers, they can't be serious about legal reform. I don't agree at all. I think they're very serious about legal reform, and I don't think there's tension. I think that, in fact, part of what's going on is this idea that, look, we're going to make it really clear that what can be reformed and what can't be reformed, and there's a separation between these two spheres. So I don't think there's any contradiction between recognizing that there's repression and recognizing that there's reform. I will say that my personal view is that if you go through, the 65 different points of reform that are set forth in the fourth plenum, the decision of the fourth plenum of the Communist Party in 2014, there's very little discussion of lawyers. And so I think that there's not enough attention to the role of lawyers in these reforms. In fact, I gave a talk in Beijing at an annual Rule of Law conference in December in which my main argument was you need to bring lawyers into legal reform, right? You need to be thinking about the role of lawyers, because unless you think about the role of lawyers, you're not going to succeed in having legal reform, right? Simply saying to the court, you're going to reform the courts without thinking about the role of lawyers, without having more space for lawyers to represent their clients, I think is going to be problematic. And frankly, I actually think it's in their interest, right? The interest of the system as a whole. They need more lawyers in this system, right? Because ordinary people don't trust outcomes, and they trust outcomes more, I think, when they're represented by lawyers, although Ethan may tell me that the empirics don't support that. They don't trust anyone, right? But no, they do trust lawyers. So I think that the main point here is I don't think there's been enough attention to lawyers. Most of the reform that's going on right now is in the courts, not in regulation of lawyers. But I think it needs to be done more. There were a couple of high-profile meetings with lawyers and law professors back in December. I will just say that I think there were some very important public interest lawyers included in those conversations. These are people who are what I'd call, T&A, inside the system lawyers. I have immense respect for them. Some of these people have done really phenomenal work on behalf of a wide range of disadvantaged groups. But I think, in talking to the inside the system lawyers, they're only talking to some of these lawyers, right? We did not see a lot of non-mainstream or even, we saw people who were very connected to the system talking to party leadership about the role of lawyers. I don't think they had enough voices in those meetings.
All right, great. So you've studied, you've been one of the pioneers in studying conservative lawyers, and you mentioned in your comments how the definitions of public interest lawyering is really a contested concept. And so I thought maybe it would be important for us to hear the sort of similarities and differences in terms of how conservative public interest lawyering plays out in the research that you've done, and sort of where there are similarities between how conservative public interest lawyers think about the type of work they're doing and how they think of themselves differently than, say, the traditional left-leaning public interest lawyers.
That's a very interesting question. I'm not sure I'll do justice to it because I haven't thought of it, and the issue in quite that way. I mean, my sense from the interviews I did, and most of these were in 2005 and 6, was that these lawyers are asserting themselves. They're really self-consciously asserting themselves as public interest lawyers. And to me, it's kind of interesting that they're doing so at a time when I think many progressive public interest lawyers are using different labels to describe what they're doing. They tend not to talk quite so much about themselves as public interest lawyers, but in more particular terms about the particular issues they're involved in. But I think they're kind of aggressively claiming this mantle that's had a lot of purchase in terms of professional legitimacy, in terms of high stature in the profession. Of course, there are
So conservative public interest lawyers see themselves as public interest lawyers? They are, yeah.
I think so. Yeah. And we're very glad that I was studying them. It's kind of like, yeah, this is about time that you actually use that label
to
refer to me.
Yeah, it's interesting. There are no other questions. I think we will conclude our symposium, and I want to thank all of our guests. Thank you so much.